My lady, my lords, we were looking at Wiltshire and First County Trust, MS 3617, paragraph 141. I just wanted to draw attention to a couple of points in that paragraph and the next paragraph. Between the letter F and G, well, just above the letter G, whether a particular statutory provision offends against any of the convention rights is an objective question to be answered having regard to all the relevant evidence. It is a task which Parliament itself has, by the 1998 Act, required the courts to perform. Perhaps an obvious point, but we look at it in this context. And then at 142, Lord Hobhouse says the question of justification and proportionality involves a sociological assessment, which, as we see from over the page at B, involves admitting the what's spoken in Parliament and so on. This has nothing to do with investigating or questioning the will of Parliament. He says at B, Parliament has spoken by passing the relevant act. The evidence is admitted because it relates to making the required sociological assessment. So that's what that's what all these materials go to, and one has to be very careful not to overestimate or overplay their significance. It follows that in convention cases, whatever is said in or by Parliament cannot of itself be conclusive, which I would hope isn't a controversial statement. So just considering the evidence in this case then, in that light, I don't propose to go through all of the parliamentary materials. The high point of the respondent's case is the Thornbury Amendment, which you will have seen reference to. We've got that in Appendix Volume 3 at MS 5518. And you'll see that she moved an amendment in, this is in committee, to insert into the bill 1007 of the paper page, my lord.
In Appendix?
Appendix 3.
Appendix Part 3?
Part 3, yes. Yes, Appendix Part 3.
What did you say the number was?
1007, my lord.
Thank you.
And it's MS 5518.
Yes, very well.
You'll see there Emily Thornbury begging to move an amendment. This is an amendment to the bill in committee. And you'll see the amendment she was proposing, regulations under this section should not be made in relation to persons A, responsible for the care of a child aged below 2. So one can immediately see the relevance of that. Although how much relevance we'll come to in a moment. But whilst we have that to hand, we'll also see what the outcome was. Just bear with me a second. Yes, at page 1007, sorry, not 1007, it'll be MS 5535, page 1024, 1024. The question was put and the committee divided, ayes 5, noes 10. So there was 15 members in the committee. So that's the high point of these parliamentary materials. What then do we say of that? We say that it's a very limited assistance to the court in its sociological assessment, as Lord Hobhouse calls it. Firstly, Miss Thornbury's amendment wasn't intended to address discrimination against lone parents of children under 2, but was a special plea for them. And don't use
Was she
the word
dealing with
special.
lone parents?
It wasn't confined to lone
No, it
parents.
wasn't confined to lone parents. You're absolutely right, my lord. I'm sorry. She wasn't, but she wasn't, the point I was making, she wasn't concerned with discrimination. And the reason she wasn't concerned with discrimination, because nobody at that time had understood that there was any discrimination. And the reason for that was because there hadn't been a proper assessment in the drafting of the legislation and the genesis of the proposals to investigate who was affected and how.
Well, what she did want to do was to make an exception for those who had the care of children under 2.
She did.
Is that right?
She did, my lord, yes. That's
Which is what you say should now be done.
But lone parents.
Lone parents.
Yes. Children under 2. Yes, and that's why we say this is the high point of the respondent's case.
Okay.
But we say that she wasn't addressing this very point with respect to discrimination, and that was because it wasn't informed by any assessment. The fact that the amendment was rejected can't be taken to mean that it was the will of Parliament not to exempt this group. The debate had, as we've just seen, only 15 members, and we can't know what the motivations of those 15 members were. That's the caution, the sort of caution that Lord Hobhouse referred to in Wilson First County Trust. The fourth point in relation to this is that the Thornbury Amendment was to the bill, not to the regulations. And as we know, the Act left the detail to the regulations rather than putting it in the Act. So it may have been, who knows, members may have thought it wasn't an appropriate thing to put in the Act. It was a matter that should be left for the regulations to deal with what appropriate groups should be exempted. And of course, ultimately, the will of Parliament is expressed in the words of the enactment itself. And the Act itself expressly empowers exceptions to be made from the cap in appropriate cases. So, taking all that in the round, we get very little from the fact that there was this debate that had that went to a vote of 15 members of Parliament. A very limited help at all in determining the justification for the discriminatory measure that we've identified in this case. Now, the parliamentary debates also, as well as the Thornbury amendment, the parliamentary debates also, as we see when we look at them in detail, refer to some of the figures that we've heard about during the course of this case. Lord Freud used the 41% figure that has been mentioned in debates in the House of Lords. We've got reference to that at MS 6122, Appendix Volume 5. Now, that 41% comes from the impact assessment that we saw earlier today. Now, if we can just turn that up again, that's again in Volume 3 of the appendix. This time at MS 5478, paper page 967. And this is relevant to the points I'm going to make, points now and the points with respect to the UNCRC. You'll recall the document that starts at MS 5477, page 966, the impact assessment dated August 2016 that we looked at this morning. If we can go on to page 10 of the internal numbering, MS 5486. Sorry, picking it up at the page before, so we put it into context. 5485, page 974, under the heading caseload. Just read the first 3 lines of that. And then when we go over the page...
Sorry, what's your...
Do you have the heading caseload, my lady?
5485, right.
5485, yes.
Sorry, okay. Yep. Gotcha.
Good. We get something of the numbers here under the heading caseload, as one would expect. But the important point for present purposes, if we go over the page, picking it up in the middle of the top line, the average total number of adults affected by the change, if they do not make the choice to move into employment or increase their hours of work or take an action to move out of the scope of the cap, is 107,000, and the number of children is 244,000. So that's the sort of numbers of children we're concerned with. But there's no assessment here of the impact on, or the numbers of children of lone parents or children that are children that are under the age of 2. So very limited scope there at all. And given that this assessment fails to recognise the particular difficulties faced by this vulnerable group, let alone assess the impact of the measure on them, it's of limited, if any, assistance to justifying how lone parents of children under 2 were not exempted from the cap. This is again looking across the piece at the materials that the Secretary of State had when going through the parliamentary process. Now, we've seen reference, we've had reference there to the 41%. To unpick that, we've got the first report of James Harvey. I'm not going to take the court to it now due to shortage of time, but if I can give you the references. Appendix Part 2, page 566, MS 5077, and particularly at paragraph 36. And what he's doing there, Mr. Harvey, is he's analysing the figures that were presented by Mr. Edson on behalf of the Secretary of State in his first statement. Now, I invite the court to read that in due course, but what we then get is a further statement from Mr. Edson. And if we can just go quickly to one paragraph in that, this is Edson's second statement, again Appendix 3, this time at MS 5428.
Other number?
917, my lord.
Thank you.
Sorry, could you give me the MS number again?
5428.
Thank you.
Which paragraph are you wanting to start?
Paragraph 53, my lord.
Okay.
I invite the court to read the paragraph in full in due course, but draw particular attention to the first sentence, which you see says, my previous witnesses did not state or imply that the official statistics showed that the original benefit cap encouraged people to work or reduce long-term dependency on benefits. And that was in light of the criticism that Harvey had made of what he'd said in his first statement. So, very important sentence in our submission. And then, in light of what Edson said in his second statement, Harvey then produced a second report. We've got that also in the same volume, MS 5457. And due to shortage of time, if I can just refer the court to paragraph 21
and the page number
of Harvey 2. If you just bear with me one moment. 941
Thank you.
at 946. And he sets out there why precisely the 41% figure is either misleading or of very little significance.
Okay, which paragraph again, please?
21, my lord.
The one, thank you.
And again, if I can invite you to read that in due course. And what that, and what Harvey says when you look at his report is that the important figure is that 9% of people who went into work as a result of the cap. That was what his extrapolation of the figures, not contested by the Secretary of State. But of course, that's of the generality. That's not with respect to lone parents of children under 2, because there was no statistics with respect to those in any event. So we get the 9% figure from Harvey to paragraph 23. Now, all this has got 2 consequences, we would suggest. Firstly, that the impact assessment provided at best an incomplete and at worst a misleading picture, regardless of the fact that it said nothing about this cohort, and the result that and as a result, the court should give less weight to the deliberations that led to the implementation of the policy, both inside and outside Parliament, because, of course, Parliament was relying on the information that it had, which was principally through this impact assessment. And secondly, the second consequence we say all this has is that when the court is conducting its fair balance exercise, it should take into account the paucity of the evidence as to the actual evidence that the policy incentivises work generally or at all with respect to lone parents of children under 2. Now, none of this, then in response to, in the latest evidence from the Secretary of State, we've got Mr. Richard Ward's evidence. Mr. Harvey has then produced a further expert report on that, which we've got at MS 10334. And what he says at paragraph 8, I won't turn it up now, but if I can invite the court to note this, that he explains that in his first report, official statistics on the benefit cap did not measure the effect of the benefit cap on encouraging work or reducing long-term dependency on benefits. And the point we're making is the paucity of the evidence. So we get these quite bland statements that actually on analysis, and when they're drilled down by experts like Mr. Harvey, are shown to have very little substance indeed.
What was the reference to his third report?
MS 10334 at 10336. That's in the additional bundle 2 of 2, my lord.
Paragraph.
Thank you.
Paragraph 8. Now, none of this means that there's not some people who there aren't some people who aren't incentivising to work by the benefit cap. That's plainly as a matter of common sense that some people will be. But it does show that there is no empirical evidence whatsoever to show that those people like the appellants who face such significant barriers to work can move off benefits and into work. We simply just don't know. And so the benefit cap's been enforced now since 2013. So we've had 5 years, and yet there's no evidence as to what its impact is on or effectiveness is with respect to these groups of people. So in all those circumstances, one point, one of his reports, Mr. Harvey says, yes, it's in Harvey 2. He says, at paragraph 10A, that he estimates that an analysis to enable the government to ascertain what the relevant figures are would take less than half a day, i.e. the numbers of children affected and so forth. And it's as far as we're aware, that simply hasn't been done. So a fairly straightforward exercise by a respected person in the industry, and there's been no contradiction of that by the Secretary of State. So in all those circumstances, we come to consider what weight is to be attached to the parliamentary materials in this case. We say it's very little, and it echoes, and we echo what my Lord Kerr said in the Brewster case. We've got it in the papers. We don't need to turn it up. It's, I think, a well-established principle. It's Authorities Bundle 5, Tab 2, MS 1238 at Lord Kerr's paragraph 64, where he said, where the question of the impact of a particular measure on social and economic matters has not been addressed by the Government Department, the imperative for reticence on the part of a court tasked with the duty of reviewing its decision is diminished. And we echo what's said there by my lord in Brewster. We would also suggest, again, with the role of the court in dealing with the statistical evidence and the caution that it should have in considering the statistics put forward to justify the measure in this case. Bear in mind what Mr. Justice Green, as he then was, said in the BAT case, that in a case such as this, in order to determine proportionality, there should be a detailed judicial engagement with the facts. That's the BAT case. That's in Authorities Bundle 5, tab 43, MS 1428, paragraph 420. And that's an important point, because that was the plain packaging tobacco case that went to the Court of Appeal, and Mr. Justice Green, as he then was, the decision was upheld by the Court of Appeal. Very extensive consideration of arguments across a whole range, every range possible, frankly, of that could have been raised before the courts. Plainly, there was a big financial incentive for the tobacco companies not to have plain packaging. And the court did what Mr. Justice Green, as he then was, says he did. He did a detailed judicial engagement with the facts. Now, we see that in a case such as this, where there's a potential profound impact on children, there should be a commensurate detailed engagement with the facts. It's not just in cases that have big commercial implications. That then deals with the parliamentary materials. Can I come finally with respect to the relationship between Parliament and the courts to deal with the often quoted sentence from Lord Bingham in the Countryside Alliance case? We see this frequently in cases where there's a friction between the courts and Parliament. I'm sure all members of the court will recall what's said, but we should turn it up anyway, I think. Authorities Bundle 5, tab 52, MS 2049. Sorry, that's the wrong volume. Is it 6? Volume.
No. It's going to be 7.
Right, 7. Volume 7. Yes, volume 7. All members of the court will, of course, be aware of the background to this case, the attack on the Hunting Act, and recalling that this was primary legislation that made it a criminal offence to hunt with dogs, unless a specific exception was made to permit such hunting to take place. The paragraph from Lord Bingham's speech is starts at page 755 of the report, MS 2085, and then goes over. Just to put it into context, if we can pick it up at paragraph 43, and you'll see the exercise that Lord Bingham's carrying out that's familiar to us all, in terms of Article 8 and Article 11 of the Convention, etc. First, 3 conditions have to be met. First, interference, etc. Second condition then set out. And then it's the third condition that paragraph 45 is dealing with, that the interference in question is necessary in a democratic society, raising the familiar questions, whether there is a pressing social need for it and whether it's proportionate to pursue the legitimate aim. And then there's reference to some case law. If we can pick it up then at B over the page, this is 2086. And he talks about changing moral standards and so forth. The degree of respect to be shown, then goes on to say, the degree of respect to be shown to the considered judgment of a democratic assembly will vary according to the subject matter and the circumstances, but the present case seems to me preeminently one which respect should be shown to the what the House of Commons decided. The democratic process is likely to be subverted if, on a question of moral and political judgment, opponents of the Act achieve what through the courts they could not achieve in Parliament. And that's the well-known sentence. I think my Lord Reid cited it in SG, but we see it in many cases where there's a friction between, or consideration by the courts of parliamentary materials. So we say that the caution expressed by Lord Bingham in that last sentence of paragraph 45 may be relevant or apt if in this case there were a challenge to the benefit cap itself and the courts were being asked to consider the lawfulness of the relevant sections of the Welfare Reform Bill. But that's not this case. We're concerned with the failure to exclude this fairly narrow cohort from the cap. And we would suggest that in these circumstances, there's no prospect of the democratic process being subverted by this claim. So we're in different territory. There wasn't a challenge to the scope of the exemptions to the hunting ban in the Hunting Act, but it was to the primary legislation itself. So there's degrees of respect, perhaps, is the way of putting it. One hesitates to use the word to use the word deference, but one has to, as Lord Bingham says, has to be put into context. One has to look at what's said there in context. So the mere fact that this is a parliamentary measure isn't determinative. And if the appellants are successful in their appeal, there would be no question, we would say, of undermining the will of Parliament in the way that Lord Bingham envisaged in the Countryside Alliance case. Finally, on this point, if I can deal with the emasculating the scheme point, again, that was a concern in the SG case, that we've seen reference in the SG case during the course of these proceedings to the impact that case would have had on the scheme as a whole had it been successful. The figures were over half, 62%. I think there was the child benefit point, but it was obviously the lone parents, as we know, as a class across the piece was a very significant number indeed. The figures here are very much
the focus wasn't on lone parents. It was on, the focus in that case wasn't on lone parents. It was on women. The argument.
Sorry, yes, you're right. Sorry, yes. A much bigger group.
And that was why the effect was so large, yes. Because the vast majority of recipients of large amounts of social security benefits were women.
Generally. Yeah, absolutely. The same concerns doesn't arise in this case, or certainly not to anything like the same extent. We saw reference earlier this morning to 24% of recipients in the snapshot that Mr. Ward that was produced. I forget where now, but it's in Mr. Ward's statement that I think we looked at this morning, where we see not the snapshot figures, but the total figures since the introduction of this measure. That's in that's MS 9828, additional bundle 1 of 2. So if we can just turn that up to get the numbers we're concerned, the numbers and the percentages, in fact. 9828, this is you'll see there table 2, cumulative benefit cap, caseload and households no longer capped due to movements into work up to February 2018 by family type and age of youngest dependent child, etc. And you'll see there, left-hand column, 178,000 is the cumulative total. Lone parent, all child ages under 2 is 31,600. And if one does a calculation of 31,600 as a percentage of 178,000, you get on our calculation, 17.75%. Nothing hangs on whether it's 18 and a quarter, 17 and a quarter, or whatever. The point that's being made is that it's of that order, it's somewhere of that order. So it's been described by Mr. Ward as very significant. You'll recall, I think Mr. Drabble took you to a paragraph in Mr. Ward's statement that that described taking all lone parents out of the scheme as emasculating, but taking this group out as being very significant. Well, significant, very significant. It's just a matter of perspective. But we would submit that to exclude just over 18% of around 18% of capped households, therefore leaving 82% unaffected, would not compromise the scheme. One also has to bear in mind, of course, that the scheme's already been tweaked to introduce various exemptions, such as the carers allowance, guardians allowance, and so forth, since its first introduction. So we're in different territory than we were in SG, with insofar as the impact of what we propose.
Otherwise, I'll go back over it, but you've done that, the exercise, from the table on 9828, have you?
Yes.
Previously, when you looked at this, you were on the table on 9825.
Yes.
Which is also repeated further on in the document at 9835, but the difference between those two doesn't matter. There is, however, a difference between 9825 and 9828. Is there a reason why you've taken
Yes, the reason's this, my lord, and a point we made this morning, if you recall, if you look at paragraph 9 on the
Obviously not,
page.
go on.
Pardon?
Obviously not, go on.
Well, if you look at, well, there's a lot of material to consider here. Paragraph 9, you'll see that was at a point in time. So as of February 18, the statistics were as of table 1. When we look at table 2, these are the cumulative figures from
up to that date,
from April 2013 to 2018. That was why, if you recall, I prefaced my remarks saying we'd seen figures earlier. I'd forgotten it was only 2 pages before, frankly, my lord. And frankly, it doesn't matter if it's 17, 18, 19, or whatever. We're concerned here with the rough figures, or thereabouts.
All right.
Can we turn then to consider the third of the issues that I set out at the outset and said that I was going to deal with, and that's the discrimination against child appellants, and specifically by reference to the United Nations Convention on the Rights of the Child. We set out this quite extensively in our written case and invite the court to look at that once more. It's at paragraphs 147 to 167, MS 8280 onwards. I'm not going to take the court to it now. Perhaps pick up some of the most pertinent points. 4 questions arise here in our submission. Firstly, whether the rights of the child not to be discriminated against are linked to or within the ambit of Article 8, because that's the route that we get into the UNCRC. If so, what is the relevance of the UNCRC? Thirdly, if relevant, is the UNCRC breached in this case? And finally, if so, what is the consequence? I.e., is that determinative of whether there is an objective and reasonable justification for the discrimination, or is it merely a weighty consideration to put in the balance? So, taking each of those points in turn, we've said a little about Article 8 and the link to and the necessary link there with being within the ambit of Article 8. And we've got that extensively in our written case, and my learned friend Mr. Drabble touched upon it. Shelter's submissions are going to deal with that as well, and to draw the court's attention to the Just Fair intervention. You'll recall there's a written intervention from Just Fair that deals with this in the interveners bundle, tab 7, paragraphs 9 to 30, MS 10498 to 10505. And draw the court's attention to that, and also the shelter papers. I'm sure Mr. Westgate will take the court to this, but just for your note, it's MS 10447 to 10452. So we say that for the reasons we set out in our written case, that we do fall within the ambit or linked to Article 8, and that the Court of Appeal was correct to unanimously find so, as did the High Court. Now, this is particularly so with respect to the child appellants, because as we see from the evidence from the mothers themselves, and we've got statements from all the mothers in the papers, but we see from those statements the impact that this measure has had on those particular families. And just in terms of hard cash, which of course is what we're primarily concerned with here, the sums are, to get them in order, with DA now being capped by £67.45 a week, EA, who's no longer an appellant but was in the frame, but she's fallen out for various personal reasons, but we've got the evidence there. She was capped by £137.18 a week. KF, the evidence there is that there's a £54 a week shortfall. And WBA, we see from her evidence that the cap resulted in a shortfall of over £200 a week. So we're concerned here with very considerable figures on what in the first place were deemed to be subsistence level benefits, and that of course is very material to whether we are linked to the right to respect for private and family life. Bearing that in mind, turning to the second of the points that we've got, the relevance of the UNCRC, the court is of course aware of the Demir principle, and it's well established now that the UNCRC informs the various convention rights. That was, I think, accepted generally by all members of the court in SG.
Sorry, what's the proposition?
The Demir principle, Demir in Turkey, the principle that the unincorporated instrument, the UNCRC, informs the convention right. And so we're reminded
but it's relevant to its interpretation.
Pardon?
It's relevant to its interpretation.
Yes, informs the interpretation of the rights.
Informed doesn't seem to be a very precise word.
Well, one can categorise it in various different ways. But what they said in Newling...
Well,
so,
anyway, we've got it.
What the court said in Newling was that the convention can't be interpreted in a vacuum, but must be interpreted in harmony with the general principles of international law. Again, it's a phrase that we see in many of the cases, and I ascertain isn't controversial. My Lord Wilson made comments to similar effect at paragraph 43 in the Matheson case, as did Lord Hughes in setting out in the paragraph in SG, setting out the three ways in which an international instrument can have an impact on domestic law. So there seems to be a general agreement about the relevance, at any rate, of the UNCRC, which of course is the particular international instrument that is concerned with, that we're concerned with. The members of the court have the terms of Article 3.1. I don't need to repeat that. We've got that in the papers. We've also got the general comment number 14, which is referred to in SG. Again, members of the court have got that. My Lord Carnwath described it as authoritative guidance. setting out the three aspects of Article 3, the interpretive, procedural and substantive rights that go along with it. But I'd also draw attention to the court whilst, if you get the opportunity, when you're looking at the UNCRC, to bear in mind Article 27.1, which is the right of every child to a standard of living adequate for the child's physical, mental, spiritual, moral and social development. And bearing in mind what Professor Bradshaw says, and the considerable sums that are reduced due to the benefit gap, as we see in these cases, and there's nothing to suggest that they're not typical, we would suggest that Article 27 is in play as well. Now, what the Court of Appeal did in this case, the majority of the Court of Appeal, we say wrongly found that Article 3 of the UNCRC was not brought into the frame, and we say that they were wrong to do so. Fundamentally, Sir Patrick Elias, we say, was wrong not to recognise the distinction between the present case and SG, in finding that the case falls within the ambit of the child's Article 8 rights only because those rights are inextricably intertwined with those of their parents. Now, it may well be that the child's rights are inextricably intertwined with the rights of their parents, but that doesn't get over the plain fact that the children themselves have rights, and they have a right to the enjoyment of their convention rights without discrimination, of course, and that's what Article 14 is concerned with. So, regardless of the relationship between parent and child, the child, it's him or herself, has their own rights to be that should be respected. So, in that regard, we say that Sir Patrick was wrong. And as we say in our written case at paragraph 156E, MS 8285, even if, which is denied, the application of the reduced benefit cap to lone parents of children under 2 is justified, just because those parents could theoretically choose to work, it doesn't follow that the imposition of the consequence of the cap on the children of such lone parents would be justified. So there is a distinction there. One doesn't necessarily have to consider the rights of the children and the parents together. So we say the UNC is plainly relevant to the interpretation of the child's rights in this case. And the appellants say that the Court of Appeal was correct to find the best interest of the child had not been taken into account as a primary consideration. So although they said, although as we've just seen, Sir Patrick said that the UNCRC wasn't brought into the frame, he then went on to find that if he was wrong about that, that the best interest of the children hadn't been taken into account as a primary consideration. That's paragraph 130 of the judgment in the court below. But nevertheless, wrong to take the tentative view that this would not invalidate the cap as regards this group within children. We'll come to the consequences in a moment. But we say, with respect to Article 3, very much as was said in the SG case, the Secretary of State has failed to carry out the best interest exercise in a conscientious and considered way. There's no more consideration of the interests of the child now than there was 4 years ago when this court considered the SG case. As we've seen, we know how many children are affected, the 244,000, but there's no analysis of how many children under 2 would be affected, and no analysis of if they are affected, what the depth of that impact would be. No understanding of the consequences for them. And so we say this is a clear case where the procedural obligation inherent in Article 3 has been breached in much the same way as it was in SG. With respect to the bare numbers, which is the first building block in understanding the children concerned, what we do know is how many households there are with the youngest child aged below 2. We get that from Richard Ward's latest statement. And what he says there, I think it's MS 9828, I'm not going to turn it up now, but what he says there, that as of February 2018, snapshot figures that we've been looking at, there was 14,300 households with the youngest child aged below 2, and that since 2013 there's been 31,600 such households count. But there's no evidence of how many children. So we know, we can say with certainty that there's more than 31,600 children, of course, but it may be 50,000, it may be 45,000, we just don't know. But given that we know it's 31,600, we can say that there's a very considerable number of children under 2 who are adversely affected by this measure. And given the numbers that were involved, we say it's truly astonishing that, that there's no understanding of those numbers or a drilling down of what the impact on all those vulnerable children are. So that's the procedural obligation. And so we go to the substantive obligation, and as the majority found in SG, to reduce the means of subsistence of children in these circumstances cannot be a proportionate act or in the best interests of children. It's a straightforward proposition, and one that is as good now as it was in 2014 when the SG case was considered. And that goes against all the basic principles that are set out in Article 3, and as my Lord Hodge set out in the Zoombas case as well, of course, which we've also got in the papers. You'll recall the 7 principles that Lord Hodge drew out there. So it's a fairly straightforward case with respect to Article 3, once you get through the procedural hoops and loops, because there simply hasn't been an understanding of the best interests of the children. Now, the latest evidence that we've been provided with by the Secretary of State, and I think members of the court have this, is the memorandum to the Joint Committee on Human Rights, which I think was sent by email to members of the court on Monday. It was sent to us. I don't know if members have got this. A lot of blank faces.
A lot of very blank faces.
No. Well, I can deal with it in reply. I'd understood that the Secretary of State had filed it with the court, but it doesn't matter. I can deal with it later. All we're saying is that this document, when we come to, if we come to it, simply doesn't answer the
What date is this document?
It's a freestanding document, my Lord.
Yes.
I'd understood the Secretary of State.
No, I understand that. What is its date?
The date? Well, it's a memorandum to the committee on the 2015 bill, undated.
I see, so it goes back 3 years.
Yeah.
When do you think it came? Monday?
Yes, my Lord. Well, Mr. Sheldon's got copies here. Perhaps I'll deal with it in reply if...
It's referred to in our case at paragraph 69(1). It was in September 2015, my Lord.
Okay.
We have copies if you want them now.
Well, if you have hard copies, it would be a good idea to let us have them, because they don't seem to have arrived by any other route.
I have to hand them up.
Well, perhaps your learned junior can help. Oh, the usher is here, it's all right. But it's probably easier if Mr. Wise deals with it in reply, because...
Yeah.
Thanks.
I'm going to take up Lady Hale's offer of dealing with that in reply, but which we will do.
Well, it was your suggestion, and I...
Yes, I think that's... Well, you haven't had time to look at it yet. We don't know what the
Exactly.
Secretary of State said. So we'll do
Thank you,
that.
Mr. Allen.
I'm struggling for time.
Thank you so much.
That leaves the... very conscious of the time constraints and the fact that we've got another issue to deal with. With respect to the UNCRC, that leaves the important question as to what the consequences of a breach of Article 3 are. We agree with Sir Patrick in that such a breach is likely to weigh heavily, is the way he puts it, in the justification assessment. That's paragraph 33 of the judgment of the Court of Appeal at MS 4526. And we say, although not necessarily determinative, it may be so. That's a matter for the court in conducting its balancing exercise. A breach will have different consequences in different circumstances. But what we say here is that the failure is so venal, so bad, that in fact, and the failure of the Secretary to even attempt to understand what the best interests of children are, in circumstances where the consequences are widespread, and we're concerned with tens of thousands of children here, and the potentially profound consequences that we know from Professor Bradshaw's uncontested report, we say that in all those circumstances, the only fair and proper conclusion that the court can reach when conducting its fair balancing exercise would be made in the children's favour. Can I then turn briefly to the final issue, and that's the common law issue. And the question that immediately arises that we take head on is why does this make any difference? Why do we have to be concerned with the common law if we win under Article 14? And that begs the question, of course, whether we win under Article 14, because there's technical hoops and loops to technical procedures to get over under Article 14. And so, for example, if we were unsuccessful on the ambit of Article 8, and we say we shouldn't be, but if we were, then that ambit issue doesn't arise when we're concerned with the common law. So it could make a difference there. Secondly, excuse me, there's no suggestion at common law that the manifestly reasonable foundation is applicable in a case such as this. And so if the court was to take the view that that's the appropriate test, the common law may make a difference in those circumstances. Thirdly, the court has on occasion taken the view that the most appropriate lens through which to consider fundamental rights is through the common law rather than a convention. And one thinks, for example, of the Osborne and Parole Board case that my Lord Reid gave judgment on. But never mind the convention, there's quite a straightforward common law point here to deal with. And that's a matter, of course, for the court as to which lens or which approach it wants to take. And finally, and perhaps the most tellingly, what we say is harmony between convention jurisprudence and the common law provides confidence in the standards of fairness required in a case such as this. And if that's right, then the common law really does have a significant role to play. So, yes, true it is that if we went under Article 14, my clients don't get any further through this route, but there are very good reasons to advance the argument in any event. So, there's 3 points. We address these issues in our written case, incidentally, at paragraphs 168 to 183, starting at MS 8288. And we stand by those submissions and rely upon them. But given the time constraints, we'd make 3 points. Firstly, and dealing with the Secretary of State's response, firstly and briefly, we'd say that the Secretary of State is wrong to say that this issue can't be decided by this court. The point being made by the Secretary of State that Lord Newberger said in KU that an issue such as proportionality under the common law should be decided by a 9-member court. That, we say, is a misreading of KU, because what Lord Newberger was concerned with there was a general importation into the common law of the proportionality standard. Now, we're not saying that that should take place. There's no suggestion that proportionality can't be an appropriate standard, an appropriate approach under the common law in an appropriate case. We're not saying that our case isn't, that it should supplant the traditional Wednesbury test. Secondly, say that the applicable with respect to the applicable test in cases such as this, a bare Wednesbury standard isn't to be applied. A more rigorous standard is required given the profound and far-reaching impact of the consequences of the measure for my clients, both adults and children. And thirdly, we say that regardless of the test applied, the failure to exempt this cohort from the benefit cap is unlawful at common law, whether the test is proportionality, heightened scrutiny, or even bare rationality. And we say that for a number of reasons. With respect to the test, before we come back to the particular reasons, remind the court of what my Lord Wilson said in KM about the intensity of review depending upon the profundity of the impact of the determination. We've got the KM case in the papers. It's paragraph 36. Authorities volume 8, tab 66, MS 2725 at 2738, paragraph 76. A fairly trite now common law proposition that the intensity of review depends upon the profundity of the impact of the determination, but nevertheless at that time it was of some debate. And we also know that with respect to the common law, the UNCRC can inform the development of the common law and rationality and whichever prism or whichever way we look at the common law, the issues through the common law. And we get that, of course, from what my Lord Hughes and my Lord Kerr said in the SG case. But there's numerous other cases as well that make the same point. My Lady Baroness Hale in Smith and Smith, for example, said something along similar lines. I don't ascertain that that's controversial, but what we do say is that this is a case in these circumstances where an especially searching inquiry is required, because there can be little more profound than a determination that removes an entitlement to benefits that the state deems necessary in respect to basic human needs for vulnerable children such as my clients. Now, with respect to applying that standard of searching inquiry to this case, the first common law point we make is the patent failure of the Secretary of State to gather all the relevant information. So we have what is essentially a basic Tameside point. And the court will recall what Lord Diplock said in Tameside about the failure to ask the correct questions and gather the necessary information in order to answer them. Well, that basic common law requirement has simply not been carried out in this case. That violates the procedural aspect of Article 3 of the UNCRC, but looking at it in this context, that procedural aspect of Article 3 replicates what the common law has said for many years. So there's that procedural flaw on the part of the Secretary of State. Secondly, there's compelling evidence that the cap will place a significant burden on these families, and so are less likely to able to mitigate that burden. That goes into the mix when considering the rationality of the failure of the Secretary of State to exempt these groups. And as my Lady Hale said, it can't be proportionate to deprive lone parents of children of the basic means of subsistence. And that then feeds into the proportionality, rationality, common law exercise. That's the second point. Thirdly, the justification is inadequate on analysis given the profound potential consequences of the measure. And again, I'd remind the court of what Mr. Justice Green, as he then was, said in BAT, because in BAT, the court was considering common law convention law and EU law, and proportionality in all those three contexts. And if one looks at the judgment around paragraph 420, I haven't got time to go to it now, you'll see that what he said about a judicial engagement in the facts relates, searing a judicial engagement with the facts, goes to the common law proportionality, just as it goes to proportionality under convention and EU law. And so we'd say that that applies in this case as well. And we've dealt extensively, I think, during the course of these proceedings with all the statistical evidence that goes into that into that melting pot. Fourthly, when considering proportionality or reasonableness, the respondents' existing exemptions are undoubtedly relevant. The fact that other people have been, other groups of people have been excluded from the rigours of the cap for reasons of not being able to work, and in that context, very similar situation to our clients. It's difficult to understand what rational reason there can be to exclude, for example, carers, and not exclude carers who are in receipt of carers allowance, and not exclude lone parents of children under 2. And indeed, it could be said that there's a stronger imperative for excluding or exempting lone parents of children under 2 than there is of carers, because carers can very often have a choice as to whether they care. They could put an elderly relative into an elderly relative with dementia could go into a home and then cease caring if that's the situation. That's pretty unlikely in truth with respect to a mother and young child, although sometimes happens. But one looks at the way in which other groups have been treated as to whether there's a rational decision making with respect to this group. And finally,
nearly at an end, aren't you?
Finally, the very final point. I think I've got 30 seconds according to my watch. And,
No.
No.
well, my watch is a bit slow. I'm sorry, I didn't see that one. The final point is the UNCRC point that also goes to rationality, and it's got particular purchase here because of what was said by this court in SG, and particularly what my Lord Carnworth said about thinking again and so on, and what was the consequence? The consequence has been 4 years later, there's been no assessment of the impact, despite that issue being ventilated fully throughout the courts, and the response has been to make the situation worse. And we will say that that's an irrational approach as well. So for all those reasons, both individually and collectively, we say that it's flawed at common law. I apologise, I hadn't seen that we were 4 minutes over time.
Well, I go by the clock here, and you're over by 3 minutes, so...
My watch needs service.
Yes. Worry not. Thank you very much indeed.
Could I, just before you sit down...
Oh, yes. Sorry.
First of all, I wondered if you had the answer to my question before the short adjournment.
My mistake. My Lord made 2 points. The first point was about the specific provisions for the childcare. We've got those, but they're a bit complicated. So can we put them into one side of A4 overnight?
Of course.
Second point about the Harvey chart.
Yes.
It's the age of the youngest child when they were last capped, is what I'm instructed.
Yes. That's very helpful.
And finally, and apologise, I should have mentioned this at the outset at 2 o'clock, with respect to the first of the issues, the difference in treatment, can I invite the court to consider the statements of Dewar and Broom, Dewar being the gingerbread statement and Broom being the Family Childcare Trust statement, about the difficulties of getting childcare. Can I just give you the references for them? The Dewar statement, I'm sorry, I forget Miss Dewar's first name. It's MS 5145, Appendix 3, 634, particularly paragraph 8. Ellen Broom, it's a short statement, if I can invite the court to read that in full. That's Appendix 3, page 748, MS 5259. And that's some of the details about the cost of childcare and the practical difficulties, which your Lordship was questioning me about this morning.
And can I just ask one other thing?
Of course.
can we assume that somebody who is otherwise a lone mother with a child who is otherwise going to be capped, if she obtains work, say at the minimum wage, is she actually better off?
We think so. Can I get back to you just to check it, because there might be a wrinkle to it. My instinctive reaction is yes, but I'd like to take instructions.
Well, the cap will disappear, won't it?
Yes. Yeah.
That's
My instinctive
the short
reaction
point.
is yes, but I just don't want to give a definitive answer.
Well, for a start, the cap disappears, but even if without the cap, which is, I think, the question, this is Mr. Drabble's point of yesterday,
Yes.
elaborated.
And it's actually the point my lady made in SG, that nobody's better off on benefits than in work. It's another way, it's the opposite way of looking at that.
Well, that was relying on CPAG, so...
Yes, I know. Well, all the tables that they produce.
But I'm really asking because my eye had lit on, in this memorandum to the Joint Committee, the government say that the government considers that the cap amounts, 20,000 and 23,000, is a sufficient amount for families to live on.
Paragraph 77.
Many working households earn less than this. So the key to that is the word earn, which is being used to mean earn, leaving working tax credit out of and other benefits out of account.
Yes.
And child benefit.
I think that's right.
Tax
I was going to deal with paragraph 77 in reply, and I can incorporate your Lordship's question into that. I'm conscious I'm taking up.
Thank you very much.
Ms Mountfield to go next.
Thank you. Ms Gallagher. I follow. Thank you. Ms Mountfield.
Lady, I'm speaking for the Commission, which is the country's statutory equality and human rights regulator, and I'm going to concentrate on two topics. The first is the correct conceptual approach to Article 14, and the second is why, and in this case how, the United Kingdom's international law obligations affect the analysis of whether and how Article 14 has been breached, and the analysis of whether the exercise of discretion so as to apply the revised benefit cap to lone parents of young preschool children is irrational as a matter of common law. As to discrimination, the Commission's submission is that the Court should take a practical and purposive approach to Article 14 and the State's obligation under that article to secure equal enjoyment of all the other rights which are protected by the European Convention. In her extensive submissions, the respondent invites the Court to take what we say is a highly technical approach to whether there is, or as in her submission, not any discrimination. First, she invites you to view the rights in issue narrowly, as comprising only the financial interests of the family member who applies for benefits on behalf of the household. Then she says, and this is for your note, MS 8419, paragraphs 115 and following, that you must identify and categorise the kind of discrimination this should be treated as is the application of the revised benefit cap direct, indirect or thlimenos discrimination. And she implies that what falls to be justified is different depending on your categorisation, which chute you put it down. And finally, she says that the Court must give very wide deference to her rationale for applying the underlying measure, regardless to the extent to which the authors of that measure have, or we would submit have not, considered matters that are relevant to the assessment of its proportionality. But we say that to insist on slotting the case as a matter of prior categorisation into a different conceptual framework is unnecessary. It adds what Lord Wilson in the AN Secretary of State for Health case called an unwelcome extra level of complexity when we're talking about, is it direct discrimination against women in Northern Ireland or thlimenos discrimination if you exclude them from a right to abortion. But apart from adding that extra level of unwelcome complexity, we say that the Secretary of State's approach to Article 14 is not only artificially technocratic, it robs it of its purpose. In particular, it prevents the Court from even considering the adverse discriminatory effect of the measure on the children who are not obviously the direct subject or target of it, but whose interests are so obviously and so seriously affected by it. On the Secretary of State's analysis, that is simply outside the scope of the Article 14 inquiry. And we say that's wrong in principle, because you should take a purposive approach, and the purpose of Article 14 should be the lodestar to its interpretation. And once you've fastened onto that lodestar, then the court can chart a sure and simple and logical course through the issues in the case. And the purpose of Article 14 is clear from both the underpinning objects of the European Convention on Human Rights and from its language. The underpinning objects are clear from Article 1 of the Convention, that says that the high contracting parties shall secure all the other Convention rights to everyone within the state's jurisdiction. And that word, everyone, reflects the starting point of the Convention. It's in its preamble, it's the starting point of all human rights instruments. At the opening words of the Universal Declaration of Human Rights, that everyone is born free and equal in dignity and in rights. And that core principle has then been cited in many decisions of this court, cases like Cheshire West and Pretty, and very recently by Lord Justice Singh, speaking for a divisional court in a case called Adath Yisrael Burial Society. I won't ask you to turn it up now, but it's in the Authorities, Volume 14, 124, on the relevant passages at paragraph 115, MS 551. And that was a case about whether a coroner would discriminate if they considered giving priority to inquests for observant Jews or Muslims to enable them to be buried promptly in accordance with the tenets of their faith. And Lord Justice Singh cited Lord Steyn, speaking extrajudicially, and he said it was a fundamental tenet of a democratic society, which is what one assumes for the purposes of the Convention, that both law and government accord every individual equal concern and respect for their welfare and dignity. And it was for that reason, Lord Steyn said, that law's necessary distinctions must be justified. So Article 14 then is the provision which embodies the state's obligations to secure everyone's rights and to give everyone's welfare and everyone's dignity equal concern and equal respect. And Article 14 says that the enjoyment of other Convention rights and freedoms shall be secured without discrimination on grounds of status. Again, to whom? To everyone. And that straightforward, literal reading of Article 14 has recently been adopted by this court in the Brewster case, and that's at paragraph 48, MS 1258. That's what Article 14 is for. So then if we turn to the revised benefit cap policy, I call it the 16 hours work requirement, because in order to avoid the cap, someone has to work for 16 hours. So it's a 16 hours work requirement. That is the policy we're looking at. How then is this court to decide whether by applying that requirement, the state has or has not secured the other Convention rights to everyone affected by the policy equally without discrimination on grounds of status? Well, we say that because the duty that you're examining is a duty to secure other rights in the Convention, the court must first identify which other Convention rights are engaged, because that fixes what must be secured without discrimination. And then secondly, the court must identify whose rights it has to consider. So in this context, where the state has chosen to confer various welfare benefits, including housing benefit and child tax credit, in order to help to provide a home and subsistence and to facilitate family life for children as well as adults, are the rights which must be secured equally only those of the adult who's the nominal claimant of the benefits, in which case you just regard the impact on the person's children as irrelevant collateral damage and outside the court's inquiry, or are the rights also those of the children in respect of whose needs the benefits are at least in part paid? And once the court has decided which rights and whose rights are engaged, only then can it properly consider the extent to which there is unequal enjoyment of those rights, the extent to which the measure which creates that unequal enjoyment is necessary to achieve some other important aim of social policy, and whether that justification is proportionate, balancing that aim of social policy and the means chosen by the democratic branch of government to fulfil that against the extent of the detriment or detriments to those affected. And that simple approach to the issue before the court has the advantage of avoiding arid technical debates, but it also gets to the heart of what it is this court is intended to do, because as Lord Dyson said in the bedroom tax case, in paragraph 46, and I think Mr. Drabble took you to it, when you are looking at what must be justified, what is the failure to secure equal access to rights that you're looking at, it's the substance of the discrimination that matters, not the form. And what falls to be justified is the same, however the inequality is articulated. So we say that the various ways in which the appellants in these various claims articulate them are all ways of framing the same fundamental objection to the 16-hour work requirement, which is the requirement to avoid the revised benefit cap, which is named, there is an unjustified failure by the respondent to secure equal enjoyment of other underlying convention rights owed to or enjoyed by their clients without discrimination on grounds of status. So you can focus, and this is one way that the DS claimants put it, on those aspects of the case which are fundamentally the same. We have a family with children claiming benefits. In order to avoid the cap, that family must work for 16 or 24 hours. So then they ask, well, why, given that the claimant of this benefit is one adult, why is there an inequality of treatment? Why does the woman, the mother, who lives on her own with children, have to work 16 hours a week to avoid the cap, whereas a mother who works with a partner who's working may only have to work 8, or under universal credit, none? Why is that? So that's what is characterised as an unequal enjoyment of the underlying right to a benefit, and they ask for justification for that. Or you could focus on the effect of the scheme as a whole and say, we have identified cohorts, either lone parents or the children of lone parents, or the preschool children of lone parents, or parents of preschool children, or parents of very small children, under 2s, and their children. They are disproportionately affected by the 16-hour work requirement, and we can see that in the statistics. So, for example, if 71% of claimants are lone parents, so people affected by the old benefit cap are lone parents, whereas 24% of claimants are lone parents, we can see there's a disproportionate effect, a disproportionate failure to enjoy the underlying rights. So that scheme obviously has the effect of failing to secure equal enjoyment of the underlying rights. So that's not the end of it, but it means that it falls to be justified. There's a distinction in the law, and that falls to be justified, bearing in mind the nature and extent of the inequality and what is intended to be achieved. Or you can take the approach that's taken in the DA case, and we say we identify particular cohorts who have a particular difficulty in complying with the 16-hour work requirement. That's the parents of the under 2s who can't get the free childcare to unlock the door to the work. And we say for them, for the scheme to be applied to those people who have particular difficulties, again, fails to secure equal enjoyment of the rights which are protected. So again, that just requires justification, and the justification may be different for the different cohorts. The harm may be worse or less bad, and so on. But the question, the legal approach is the same. Those are all ways of responding to the same overarching question, which is, does this measure, the 16-hour work requirement to avoid the revised benefit cap, secure equal enjoyment of the rights protected by the scheme, or are relevantly similar people treated differently by the scheme, or relevantly different people treated in the same way by the scheme, which means that it has a different effect on their enjoyment of rights. So then I turn what that means for how you do your analysis. We don't intend to duplicate, but we do adopt what has been said by the Court of Appeal in this case, and by the appellants and Shelter and Just Fair, in saying that this is a case which falls within the ambit of the Article 8 rights of both the adult claimant and the children whose family life and home are affected below by the measure because their lone parents cannot meet the requirements that they work for 16 hours a week or find it disproportionately difficult to do that. And it follows, therefore, that this payment of benefits falls within the ambit of another convention right, given its purpose and function, and therefore the state is under an obligation to secure equal enjoyment of that right. So we say it's not just a question of whether the state is justified in failing to secure some property right of the adult. The question is also whether it's justified in failing to secure an equal enjoyment of benefits for children, which are within the ambit of a scheme adopted by the state, that's the welfare scheme, in relation to the children's rights to enjoy family life and private life and home. And that is why, with respect to Sir Patrick Elias, he was wrong, we say, in paragraph 128, to say that it really made no difference if the underlying convention rights were the parents' rights alone or their dependent children's rights, because the children's rights were dependent on what the parent could or could not do, because the nature of the detriment for the children is worse. And once you recognise that that's not just collateral damage, that's something that this court must consider, because it is within the Article 14 inquiry, then the interests of the children may be very difficult. If you take a mother and say, it's tough that while you find it virtually impossible or very difficult to get work while your youngest child is 2, you may be hungry, you may be cold, and then you'll be able to go out and get work. As Professor Bradshaw shows, the developmental consequences of that for the child may be lifelong. It's a very different matter what happens to a child at a crucial level, crucial point of their development. And that's why it is particularly important to recognise that it's not just the interests of the parents, but the children too, who matter. We adopt what Lord Wilson says in Mathiasson about the reluctance of the court to conclude that an applicant has no relevant status. The reason of principle why that is right is because Article 14 is intended to secure equal enjoyment of other convention rights to everyone, to reflect each individual's equal dignity and worth, and that is why the Court of Appeal was right to say that identifying a cohort where a measure has a particular effect is enough to trigger the Article 14 inquiry. Now, it is right to say, as my Lord Hughes was saying earlier in questions, that how different the detriment suffered by this cohort is from the detriment suffered by the whole group may well be a relevant question to justification. But when one says whose rights may be adversely affected, how do we look at that adverse effect? The answer is the group that claims an effect against it in comparison with all those to whom the scheme is applied. So if it's a benefit cap applied to anyone who applies for wealth anywhere, anyone eligible for welfare benefits, unless their family unit is somebody's working 16 hours a week, then the question is, how bad is it for lone parents in comparison with all people applying for welfare benefits, or how difficult is it for lone parents of preschool children in comparison with all, or under 2s in comparison with all, and their children. So that's the status groups that one looks at. It doesn't matter if there's another cohort that might be adversely affected, or you could frame a different discrimination claim. If the cohort about which the complaint is made can point to a prima facie failure to secure equal enjoyment, then the justification exercise is triggered because of the right, the respect, the equal respect that everyone enjoys. So that's also the reason why articulating how different this cohort is part of the justification exercise, and why, again, with respect, we say Sir Patrick Elias was wrong in principle to say that one had to decide how seriously status-based differences impinged on someone's ability to find work before deciding the question of justification rose at all, and saying, I can see there are difficulties for all sorts of benefit claimants trying to seek work with small children, so there's nothing to justify. If one can show that at least prima facie there's a particular difficulty for this group, or a particular difference in situation that should be recognised, then the justification question it comes back in as part of the non-technical approach, because call it direct or indirect or thlimenos discrimination, borrow categories from other ways of looking at discrimination from other legislative schemes, but they are all ways of getting to the core question, which is whether the state has failed to secure equal enjoyment of the protection it affords to another convention right in a way which calls for justification. When it comes to justification, the four-stage structured approach, which is common ground, applies, does not mean, assuming there's a manifestly without reasonable foundation test in this context, that doesn't mean that the court totally capitulates and says it is for the executive to decide effectively if this is proportionate bar complete irrationality. We would adopt the approach in Brewster and in A and B and the Secretary of State for Health, that the question of fair balance is always one for the court. And that is an approach that Lord Wilson took in the A and B case at paragraph 33, with Lord Reid and Lord Hughes concurring. But we accept, and indeed aver, because it's important as a matter of mutual institutional respect, that even at that fourth stage, the court can, and it's right that it does, afford respect to the initial analysis and initial judgment of the decision maker. But, and this is important in the context of this case, this principle can have little or indeed no practical application in a case like this, where, despite the observations of the court in SG, there is little or no evidence of an informed or structured evaluation by the primary decision maker of the key questions that this court must answer. And we've set out in our written case, and it's so familiar I won't take you to it, but the observations by Lord Mance and Baroness Hale in the Misbehavin case, MS 8606, it's paragraphs, well, my reference seems to be wrong, but around paragraph 47 of Lord Mance and paragraphs...
I suspect every member of the court is familiar
yes, exactly.
with those
The key question, but the court has been deprived of the assistance and reassurance of that the decision maker's considered opinion, and that means that it is going to have to form a more considered evaluation of its own. And I'm aware that members of this court are properly concerned not to overstep their constitutional role in a case of this kind, in a case of political controversy. But it is in such a case that the court has an established constitutional role. May I ask you please to turn in volume 1 of the authorities bundles, tab 11. It's the Reed G case. To what Lord Hope said at paragraph 48, it's MS 174. Obviously a very controversial area, whether unmarried couples could adopt in Northern Ireland. So paragraph 48 is at MS 174, and Lord Hope recognised this was a controversial area of social policy, but then by letter E he said, cases about discrimination in an area of social policy, which is what this case is, will always be appropriate for judicial scrutiny. The constitutional responsibility in this area of our law resides with the courts. The more contentious the issue is, the greater the risk is that some people will be discriminated against in ways that engage their convention rights. It is for the courts to see that this doesn't happen. It is with them that the ultimate safeguard against discrimination rests. And there's also similar observations by Baroness Hale at paragraph 122. So it is for you to decide if the defendant has failed to secure equal enjoyment of the rights it has chosen to protect. And to take the Quiller metaphor of a sledgehammer and a nut, here the main nut is to incentivize people to go back to work. So if in 5% of cases that works. And in 95% of cases, sledgehammer still comes down. It doesn't solve the problem of getting people into work, and it causes really severe detriment to the children in that family, real misery. Then it's not only not a very good sledgehammer, because it doesn't crack nuts very effectively, but it does a lot of collateral damage. It is for you, the court, as a matter of constitutional function, to say that is not a proportionate measure. It is failing to secure equal enjoyment of the underlying rights in a very serious way, and it can't be justified, even though the objective of getting people into work, that's a matter for the elected branch of judgment of government to decide how important a role that is. I'm now going to turn and Mr.
You've only got a minute or two.
I have got it, yes. Mr. Westgate has given me 5 of his minutes, if that's all right with the court.
Yeah.
But I'm going to turn briefly.
It's all right with Mr. Westgate, it's all right with us.
To the relevance of international law. I said that in another case and was told I had to ask the court. So if it's all right with you, my lady, I'll take 5 of Mr. Westgate's minutes. We rely on our written case, paragraphs 35 to 48, for the constitutional principles as to why and how this court can properly take international law into account to inform the question of whether discrimination within the ambit of another convention right arises, to inform the question of justification, and to inform the common law. And we also explain in our written case, and it's important to highlight this because it's a point the Secretary of State takes, paragraphs 44 to 46, MS 10,483, that there is clear authority that it is for the court to decide which international law is relevant, how relevant it is, and what it means. It's not for the executive, it's for you because you're a court. Insofar as these questions come into questions of domestic law that are for you to decide, you decide what they mean and how relevant they are. And you have already indicated, this court has already indicated, that it will use general comment as authoritative guidance, not of course as binding authority in the sense of precedent in this court, but at least requiring careful consideration. We've then set out, and I won't repeat from paragraph 47, the provisions of unincorporated international law and the general comment on them, which the Commission considers particularly relevant. They really fall into 3 categories. The first is those provisions. We have Article 9 of the International Covenant on Economic, Social and Cultural Rights that says everyone has... So the first is rights that recognise that everyone, including children, have rights to social security, and that children's rights are relevant to deciding what is needed. The second is anti-discrimination guarantee, and the third is best interests. So we have Article 9 of the International Covenant says that states parties recognise the right of everyone to social security, including social insurance. And Article 10.3, which we set out the relevant part on MS 10483, specifically says that special measures of protection and assistance should be taken on behalf of children and young persons without any discrimination for reason of parentage or other considerations. And that chimes, if I can ask you to turn over the page to MS 10,485, paragraph 54, to Article 27 of the UN Convention of the Rights of the Child. Article 27.3 provides that states parties shall take appropriate measures to assist parents and others responsible for the child to implement that right, and shall, in case of need, provide material assistance and support programs. So the emphasis is on the needs of the child, not the state's desire to encourage certain forms of behaviour in the parent. And I'm flipping about a bit, I'm sorry, but if I turn to the previous page, paragraph 53, Article 26, says that all children should be able to benefit from social security, and the benefits should, where appropriate, be granted taking into account the resources and circumstances of the child and persons having responsibility for the maintenance of the child, as well as other considerations. So if one's saying, are these rights really just property rights of the parent, and children may or may not benefit from whether their parent is rich or poor, but they're not really the child's rights, we say these provisions indicate that these clearly are rights intended to be closely linked in fact and law to the children. So that's the first point. It ties it into Article 8 and it suggests there is the relevant nexus with the rights of children for the best interest principle to apply. Second, international law confirms that children must not be discriminated against in the context of a claim for benefits, either because of their own characteristics or because of those of the parent upon whom they depend. Parentage may originally have been intended to mean legitimacy or illegitimacy, but the fact is that the child's needs should be focused on, and one shouldn't say, I'm very sorry that that creates enormous difficulties for you as the child of a lone parent. In particular, we know that, but we want to encourage people to bring up children in families or something of that kind. So children mustn't be discriminated against even in a derived way. And the defendant suggests, MS 8246, paragraph 137, that the impact of this measure on children is in some way less protected because it is merely an indirect and contingent effect. Indirect and contingent because we're trying to encourage the parent to work. These international law provisions suggest that that's a very poor argument. And then thirdly, the procedural and substantive requirements of Article 3 of the UNCRC are relevant to determining whether there is a disproportionate breach of the child's Article 14 rights read with Article 8, or even the parents' Article 1, Protocol 1 and Article 8 rights when the children's interests are taken into account and their best interests are taken into account. And I won't repeat what's said in oral submissions and written cases for others on that part, but we do say there's a striking lack of evidence of any such evaluation given what the observations of this court in the SG case. What I do say is that breach of the procedural obligation supports and feeds into the submission I make on the misbehaving principle. The Commission is very conscious of the appropriate constitutional role of the court and other decision makers, and the reason that this court ought to look particularly closely at the question of fair balance and justification is precisely because there has not been the evaluation which this court might expect, particularly when one looks at the procedural aspect of Article 3 of the UN Convention of the Rights of the Child, to which the government has bound itself or bound the state as a matter of international law. In conclusion, on the impact of international law, the application of the 16 hours a week work criterion for receipt of uncapped benefits and the application of that criterion to families of lone parents which contain a child under 5 or indeed a fortiori child under 2 is incompatible with two clear, consistent and relevant principles of international law. The first is that children in need shall enjoy the same social protection without discrimination on any grounds to do with themselves or their parents. And that may mean recognising and responding to their different circumstances and their different needs. And the second principle of international law, which is breached by the 16-hour work condition for the receipt of uncapped benefits, is the principle that the best interests of the child shall be a primary consideration in all actions concerning children. So to conclude by returning to the core question as to the breach of Article 14, bearing in mind the different groups and the evidence before this court, both statistical evidence and qualitative evidence about the particular effects of that 16-hour work requirement on the particular groups of parents and children before the court, has the state secured to everyone in its jurisdiction the equal enjoyment of the other relevant underlying convention rights protected by that scheme, which are within the ambit of Article 1 and Article 1 of the First Protocol? Has it protected the equal enjoyment of those rights of all those in the jurisdiction who are affected by the revised benefit cap, without discrimination against the identified groups of lone parents and their children before this court? The obvious answer to that is no, because the conditions for receipt of benefits have the effect of providing less protection and less respect for family life and private life and the home of children of lone parents, especially very young ones, as a result of their family status. And when Article 14 is interpreted compatibly with the United Kingdom's obligations in international law, there is a failure to ensure equal enjoyment of the claimant's rights, which is not proportionately justified, which even as a matter of common law is irrational. And it's the Equality and Human Rights Commission's view and submission that these appeals should be allowed and the cross appeals should be dismissed. Thank you. Sorry, it's going to be a bit of shuffling.
Mr.
My Lady
Lords.
Lords, Shelter's intervention in this case is principally to make points going to justification about the reach and impact of the CAB and about the failure of mitigation measures or options that are said to be open, such as DHP's, discretionary housing payments, or the possibility of moving home, and in particular the failure of the Secretary of State to properly take account of those matters or to investigate them. But before I get on to that, I need to say something about the ambit of Article 8, which, as Mr. Wise indicated, was something that we would be picking up. It's something on which the DA claimant succeeded, both before Mr. Justice Collins and in the Court of Appeal, and it's been developed in detail and printed cases. I won't give you the references, but and I don't intend to repeat what's said there, and in particular we associate ourselves with the way in which the point is put by Just Fair in their submissions. But in DA, both courts below were right to hold that the facts of this case are within the ambit of Article 8, both in respect of the claimant parents and their children. And I preface what I'm going to say about that really by considering what the Secretary of State is setting out to do with the benefit cap. And there are really 5 points I want to make. Firstly, they're trying to achieve long-term behavioural change. That's something that goes through all of the statements. Secondly, it includes going into work or moving into work for the parents, and for which purpose the respondent prays in aid the availability of free childcare and help with the costs of childcare. Thirdly, it may include adjusting the family budget, and as we'll see, that can be a drastic adjustment. Fourthly, it may include moving home, although again, as we'll see, that is, as a matter of fact, problematic, but it's something that the Secretary of State has had in mind. And all of this is said to improve the life chances of children, this is the 5th point, who not only are going to be helped out of poverty, but are going to be set the example of living in a working household with all the benefits that will bring. And on top of all of that, the mechanism for doing this includes capping housing benefit, child benefit, and child tax credit, which are expressly directed towards maintaining the home and the position of children, respectively. And entirely unsurprisingly, we say, Sir Patrick Elias saw this as a modality of the exercise of Article 8, stressing, as he did, the purpose of housing benefit to enable families to live together in appropriate accommodation and the work incentives. And that, we say, is an entirely orthodox approach, because what he relied on went far beyond simple incidental consequences or side effects of a financial provision. And we make 2 points in addition to the matters that have been raised in skeleton arguments. Firstly, although the Court of Appeal didn't rely on this, the conclusion is supported by the decision of this court in Carmichael, which is Core Authorities Volume 1, Tab 10, MS 140. I'm not going to take you to it because of time, but in that case, a couple who couldn't share a bedroom were held to have been discriminated against in their Article 14 rights taken together with Article 8, when what's described as the bedroom tax was applied to them. Now, the respondent doesn't say that decision was that case was wrongly decided. They say it's confined to its facts because there was an obvious connection with, they say, the core of what Article 8 protects. But the difficulty with that is that the same reasoning must apply to other cases. And in effect, the finding there was that there was a breach of Article 14 because there was discrimination in respect of cases where there was a transparent medical need for additional accommodation. And if that's the case, then it can't be limited to the particular fact of not being able to share a bedroom in that case. And we suggest that the underlying point isn't difficult to find. It's that housing benefit is a benefit whereby the state shows its respect for family life in making a contribution to accommodation costs. And it's clear authority that housing benefit falls within the ambit of Article 8. We also say that Sir Patrick Elias's approach was entirely consonant with the approach in Strasbourg and domestically. And the key point I make here is really something that follows from Ms. Mountfield's submissions, that as with other aspects of discrimination, the European Court here adopts a non-technical approach. And the various formulations that one finds reflects that. what the court asks is whether the facts of a particular case fall within the ambit of Article 8. One gets that from Petrovich. I'm afraid because of time I'm not going to have to be able to take you to that, but it's Volume 12, Tab 102, MS 406. And that's been followed in numerous cases since then that are footnoted in the written cases. In other formulations, the court refers to the subject matter of the disadvantage, or whether the measures are linked to the exercise of a right guaranteed. It's well established that that doesn't require a substantive breach of any particular article, and also that where some specific provision, not mandated by Article 8, is a modality of the exercise of the right, then it will be within the ambit, at least where there's a more than tenuous link. For that point, Lord Sir Patrick Elias at MS 4545, citing Smith and Lancashire. And for those purposes, a measure will amount to a modality if it's intended to promote family life or a way by which the state shows its respect for family life. And within that rubric, we have Petrovich, which was a case about parental leave, Ockpis in Germany, which involved child benefit, we would also draw attention to Trizio in Switzerland, which was a disability benefits case, where the court asked whether, not whether the measure was intended to have a particular effect, but whether it was apt to do so. And that's a case that shows that the impact of a measure, a financial measure, can be sufficient in itself if it has a sufficient impact on family life. Significantly, what we say is that in none of those cases does there appear to have been any element of requirement to pay the amounts that were the subject or which brought them within family life on that object. So, for example, in Trizio, the benefit was to compensate for disability and it wasn't required to be paid in a particular way. And secondly, in none of the cases does one find any focus or attention given on any formal expression of the object behind them, and nor that they distinguish between sole or multiple objects, or between principal or subordinate objects, or between means as opposed to ends. It's instructive that in Petrovich, the Commission used the words whether financial assistance was destined to promote family life. And all of that, we say, points to the Secretary of State's approach being inappropriately narrow, because they seek to focus on the detail or narrowly expressed wording of the policy to try and identify a dominant object, and their other points are in a similar vein, and that's simply out of kilter with the general approach of the Strasbourg Court. For similar reasons, we say that the attempt by the respondent to say that the test in Strasbourg is in some way supplanted by the approach of Lord Bingham in Clift is misguided. We deal with that in our case, and I'm not going to repeat that. But even if one asks, as the Secretary of State suggests, whether what's being done is close to the core values of Article 8, then one really arrives at the same answer. To use the just fair formula, what we have here is a state measure designed to induce people to make choices about whether they should work or look after their children or move home. And all of that falls within the ambit of Article 8. If the facts do fall within that ambit, then that's so for the children as well as their parents. We make that point in our skeleton, in our case at paragraph 17. And finally, before leaving this, we make one point about that there being another way in which Article 8 can be said to be engaged here, particularly for younger children. And you've heard, particularly in the submissions of Mr. Wise, about the impact that living in poverty has on children in their early years, on their health, their education, their educational achievement, their emotional well-being, as well as their more general life chances. Now, if one compares that to the list of matters referred to as being within the scope of Article 8 in the decision in Pretty, to paragraph 61, it's MS 4149, then one can very readily come to the conclusion that those matters in themselves, when one has a measure which is directed to lifting people out of poverty and so directly impinging on those matters vital to a child's development, is itself something that brings it within the ambit of Article 8. If I can move on now to the remaining submissions that we have, which go to justification. And we accept that many of the points we make can be said to apply to all people who remain capped, and not just to the particular cohorts that are in issue here. But we say that doesn't matter at this stage in the argument, because once one has seen a difference in treatment, then it's legitimate to have regard to the severity of the measures in asking whether they strike a fair balance or whether there's an excessive burden. And what we seek to demonstrate is that the reach of the cap here is far greater than the original cap. And while there's evidence that the Secretary of State deliberately intended to extend it beyond London, they failed to take account of the consequence that would then make moving to escape the cap illusory. And secondly, a related effect is that the cap's liable to push families into serious poverty. And thirdly, and this is really a theme which has perhaps emerged in the course of the last 2 days, that the Secretary of State has failed to take either of those points properly on board. And they still haven't really answered them, except to make assertions about the general availability of DHP for hard cases, or that working single parents choose not to work, or that the amounts left by the cap are adequate. And that, of course, feeds into justification because it's legitimate for the court to discount the reticence that it has about interfering with a matter of this kind if it hasn't been considered by the decision maker. It's the Brewster point that was made earlier this afternoon. So if I can deal with those points, first of all, with ability to negotiate or move away from the cap and the defendant's fairness justification. What I'm really doing here is picking up headline points from the statement of Shelter. It's neat. As was noted yesterday, the original cap was felt most keenly in London. It's not quite more than 50%. There were 42% of cases in London, but there was also a concentration in other urban areas. Now, only 25% are in London. But the important point we make is that the effect is so widespread that, at least in the private rented sector, if you have 3 or more children, then you're going to be capped everywhere in the country. And that is graphically demonstrated in a plan at page 10525 in Ms. Neat's statement. So one can't escape by moving. And we also know from Ms. Garnham's latest statement that 74% of capped households have 3 or more children. So it's something that is geographically and spread throughout the cohort. Also, you can't escape the cap by negotiating a lower rent. Only 1% of people have managed that. And the effect of all of this is going to get worse as time goes on, because there's no commitment to increase the cap with the cost of living, and it's already been eroded by inflation since it was announced, and has lost something like £1,000 of its value. Even if there were places to move, there are a series of obstacles that make that unlikely. I won't go into the details of those. They're dealt with by Ms. Neat at paragraph 35 of her statement, 10530 of the electronic bundle. And all of this is important, we say, when it comes to consider the fairness rationale, because as Mr. Drabble demonstrated yesterday, moving was flagged up at the time of the original cap as one of the choices that capped households were encouraged to make. In particular, his references at page 6336 and 6368 for the old impact assessments and 5478 for the August 2016 assessment. And so it was part of the architecture, if I can put it that way, of the fairness objective. If you can't or will not work, then move or reduce your costs, was in effect the message that the cap was giving. The evidence put in by the Secretary of State in the Secretary of State's case emphasises this less, but the point is still there. You saw the impact assessment from August yesterday. It's in Mr. Edson's statement in DA at 4995. And importantly, it's still in the housing benefit guidance. Again, for time reasons, I can't take you to that. But I do invite you to look in particular at page 4311, where the current guidance is set out, and in particular paragraph 1.17, because that paragraph refers to the potential options of reducing your rent or moving. It expresses the intention that, or the expectation that the majority of people will go into work, and if none of those things happen, suggests they should reduce their costs. And so the way in which DHPs are being presented to local authorities is being put in that respect on a basis which is, we would say, wrong in every particular, because none of those options are ones that are realistically open to households who are capped. It appears from the rest of the material that there's been no recognition by the Secretary of State of the difficulties that families would have in not being able to move. And there's no explanation why that wasn't the case. And it's surprising that this work wasn't done, because it's really a matter of arithmetic and desktop work. You'll see that when you look at the statement of Ms. Neat. But of course, what it does mean is that neither the Secretary of State nor Parliament were properly apprised of this issue when it approved the measure and the effect that all of it had. And it also has the effect, we say, that a flagship mitigation measure hasn't been properly evaluated and is presented on a basis that has no reasonable foundation in fact. The second point I make, and I'll take this as swiftly as I can, that the actual losses suffered by capped households, the housing benefit guidance refers to making up the shortfall in your rent, and Shelter also did some work on that. And the headline points are that, again, if you've got 3 or more children, you're going to be in relative poverty everywhere in the country. That's below the 60% median earnings. But in addition, and significantly, the reduction is so great that in a number of areas of the country, larger families at least, are going to be reduced to levels of serious need. And to arrive at that, Shelter used a basket of goods similar to the one used for asylum support. And they then took the amounts that households with the bottom 10% would spend on those items. There are various reasons why that may underestimate, in fact, what families are spending. But if I can ask you to look at, in due course, the table at 10.537 and the map at 10.538. And the only point that's taken really against us on that is that we've used a subjective measure. That's Mr. Ward's statement. But what he doesn't do is look at the list of goods and items that we've identified and pointed out anything that he says shouldn't be there. So he hasn't put forward any alternative measure, unless that is he's suggesting destitution in the sense of real deprivation of shelter and basics like that. Again, it's a matter of desktop research. There's no explanation why the Secretary of State didn't do that before introducing this measure. So what does all this mean for homelessness? The short answer is we don't know. We know there are some very important changes that are happening in the homelessness environment. Far more people now present as homeless because of the loss of a private rented tenancy. Homelessness has increased, and where research has been carried out, and councils have been able to give the figures, they report high level of arrears in capped households, 44% on average in arrears. But despite that, the government hasn't carried out any recent analysis of welfare reforms and has even stopped collecting relevant data. And we get that again from Ms. Neat at 10541. And so what we say is that this, of course, has important implications on the fairness rationale, because the defendant didn't evaluate key impacts or mitigations. And they don't indeed appear to have any data to set against that which Shelter have produced. That undermines the reasonableness of any conclusion they reach, and hence the foundation for any claim that the cap's justifiable. And it certainly when one comes to the fairness rationale. But it also means that they're in no position to say what the cost savings are. Because Mr. Drabble demonstrated that when you take account of DHP and other benefit costs, then the suggested savings are much more precarious than they've been suggested. But to that, one now has to add another large unknown, which is, well, what's going to be the impact on homelessness? Because the statement of Ms. Garnham, her second statement, points out that the cost of processing an application in a 2-week stay is £6,700 per case. Now, if the stay goes on for longer, then, of course, the costs go higher. And none of that's been factored in. Finally, can I make 2 very brief points about discretionary housing payments? The respondent relies on these as an element in justification, saying there are much better means of addressing hardship in particular cases as compared with arbitrary and blanket exceptions. That appears to be implicit in that they accept that they're not suitable for wide-scale structural difficulties. And if that's the point they make, then we agree with them. We've explained a number of the reasons why DHPs aren't a solution in our skeleton. I won't repeat those, but I do make 2 points. The first is that the respondent has pointed to an underspend in that authorities are returning certain amounts of money, close to £8 million now, from the subsidy that they're given. They refer to the most recent data, that's not in your bundles, that you get an idea of what they're talking about at page 83H2. But what it shows is that 30% of authorities spend above or at 100%. Many authorities spend in the 90 to 100 bracket, and the vast majority of them spend somewhere between the 80 or above 100%. And again, the difficulty here is there's been no research as to what it is that local authorities are doing with DHPs. And when one goes back to some of the earlier material about Wave 2 surveys, it shows that authorities were conscious that they had found it very difficult to judge when payments would fall due. Some just spent until they ran out, and that happened in Southwark in the Hurley case. Others try and anticipate, but then of course may find that they're left with something at the end of the year. The simple truth is we just don't know. And the reason we don't know is the Secretary of State hasn't done any research on it. The second point I make about DHPs is about whether this is a hard cases case. Because the reality is that when one looks at the cohorts, however one describes the cohorts, whether it's the whole lone parent cohort or a smaller group, one is dealing with a situation where only a minority of that group go into work at all, and a much smaller minority are incentivized to go into work. So what one has is a large group which is subjected to the disadvantage for the suggested benefit of incentivizing a very small group. And so what the Secretary of State's got to do is say, well, even though the cap doesn't induce most people who are affected to work, and even though it causes hardship, including to children, real misery, in the words of Mr. Justice Collins, it still strikes a fair balance because of the incentivization potential. And if the case is put in that way, then that proposition can't really be sweetened or ameliorated by relying on DHPs, because the truth is this isn't a case, as perhaps MA might have been described, of a policy that applies legitimately to an entire group, but where there are a few hard cases. What you've either got is the entire class that is inapt for inclusion in the rule, being the hard cases, in which case your DHPs are being used as a substitute housing benefit system, for which they're absolutely inappropriate for reasons we give in our case. Or what you do is say, well, the hard cases are going to be the cases which are the ones that are very, very harshly affected. But the difficulty with that is that you then have a middle group of people for whom the rule doesn't really have any purchase, but for whom you're making no provision in your DHP system. So either of those options isn't a solution, and they simply expose what we say is the fundamental problem here. This just isn't a hard cases case. The problem with this rule, no matter how one defines the cohort, is that it strikes against a majority group for changes that are said to apply to a tiny minority. I'm afraid I've run over a little, but unless you have any questions.
No, thank you very much indeed, Mr. Westgate. Yes, thank you.
Thank you.
Well, at long last, Mr. Sheldon, you will get your go. We're always very anxious to avoid the impression of ganging up on the government, but sometimes we do have to hear from important interveners. But you will have your say tomorrow, and we look forward to hearing from you at 10 o'clock tomorrow morning. The court will now adjourn.